I'm Alastair Hudson, and this is the introduction to commercial trusts law. Just to explain, there are 3 trusts law courses currently on this programme, so just to explain how they interact. There's international and comparative trusts law, which looks at specific questions of using the so-called offshore jurisdictions to manage assets, avoid tax, avoid regulatory oversight, and protect clients against insolvency principally. And statutes in some of these other so-called offshore jurisdictions have different rules to English trust law. So that course is primarily concerned with looking at how English trust law is structured in that sense, and then what the differences are in other jurisdictions, the offshore trusts rules and asset protection trust in particular, and then drawing some themes out of that about what that means about the nature of the trust internationally. There's equity and trust in context, which takes some of the key principles of equity and trust, as you may have studied them on an undergraduate programme at a UK university. That is, the constitution of express trusts, the nature of trusts implied by law, breach of trust and equitable remedies, and then trusts on the home. And goes into all of that in much greater depth, goes into that journal literature in great depth. As to how that area of law functions, and tries to move it beyond any law you might have considered before. It also offers a basic introduction to English trusts law, the full range of English trust law, for anyone that hasn't studied English trust law before. What this course is about, commercial trust law, is to look particularly at how trust law is used in commercial contexts. And I think the difference is important because in recent years, because this area of law has become more and more complex, that means the litigation has become more complex as well, and therefore it tends to be parties with very deep pockets, large corporations, high net worth individuals who tend to have been engaged in this kind of litigation, or else it's needed people who've been legally aided and therefore the state has been paying their legal fees for them in effect. So that means that a lot of the recent case law, from the 1990s onwards certainly, we've had a lot of very important cases in this field, but they have tended to involve banks and large commercial entities in many, many cases. So this course considers how the trust is used commercially. It considers how it's used by commercial entities, by banks and other financial institutions, but also large corporations to achieve commercial goals, and how some of this case law filters into all of that. So, just to give you an idea of what the 4 sections of this course are, we begin in section A by looking at the nature of the trust and how it's used in commercial circumstances. Now, there's been a real body of academic journal literature in the USA and in England and Wales, which has argued that trusts should be thought of really as being contracts. And the thesis is this. The thesis is because most of these high net worth individuals or these commercial organisations employ professional advisors to act as their trustees, there is always a contract between the client there and the professional advisor, as well as there being a trust. And because a lot of the argument that's run through the International Comparative Trust Law course is that there are lots of old principles in English trusts law which get in the way of people being able to achieve their goals in the 21st century, avoiding tax, protecting themselves against insolvency and so on. Rules like the beneficiary principle, that there must be a beneficiary, that you can't have a trust purely for an abstract purpose. Lots of people have argued that those rules should be stripped away from English law so that it would make the English law trust more attractive to various kinds of investors, the sort of investors that invest offshore at the minute. And what that would mean in terms of commercial trust law, it's said, is that we could start to think about the commercial trust as being something that is really based on contract. We could think of exclusion of liability clauses in contractual terms as well, and we don't have to keep talking about equitable and fiduciary concepts. Now, all of this is a complete anathema to a traditional English trust lawyer. The basis of the trust is the proprietary right of the beneficiary. All of this is complete shock and awe to most commentators. So a large part of the opening bit of this course is about thinking about exactly that debate, pretty much for the soul of trust law. Because there's a very, very interesting remark in a judgment by Lord Brown Wilkinson in the House of Lords in Target Holdings and Redferns, where his lordship held, maybe in the future there's a need for trusts law to divide between the traditional family type trust on the one hand and commercial trusts on the other. And really this course is taking that seed on slightly and thinking, well, actually, Is that what we should do? It's following through these trends in the case law and in a lot of the academic literature, really, in the US and in the UK, and asking whether or not we should be creating some commercial trust principles. So in this course, we'll also ask, the traditional trust is supposed to be based on an idea of conscience. Does that have any commercial utility? And while your instinct might be to say no, conscience doesn't sound like a very commercial concept. Actually, if we look at financial regulation, if we look at commercial regulation generally, for example, the Financial Conduct Authority rulebook here in the UK, we see that there is a principle of integrity at the very heart of that. Rule 1, you must act with integrity, full stop. Now that seems to me to be very similar to you should act in good conscience. There's a similarity of approach there, even if the words are slightly different. And so that might make us say, well, actually, the forefront of commercial and financial regulation has a very traditional, equitable feel to it in that way. We should interpret all of the detailed rules by reference to that high-level principle. So that's at the basis of this course as well. Actually, is there some utility in those old ideas? Maybe we shouldn't dismiss them as being old-fashioned. So that's section A, that's where we start. We then move on into the very, very practical commercial activity of taking security. How do we use the various equitable devices that are in existence to take security in the future? I think this is fascinating. We run through the entire gamut of how we'd use trusts to take security against someone else going into insolvency or failing to pay us or whatever. We also think about mortgages, charges, liens, pledges. We look across the entire waterfront and think about how those different legal, principally equitable techniques are used to take security. You're asked to solve practical problems. You're also asked to write something in the form of essays, in effect, in your exam, if you prefer to go down that route, where you consider some of the issues and some of the benefits of using some models to take security as opposed to others. So that's practical. In section C, we look at the recovery of property in commercial litigation. So if in practice our trust has been breached, for example, how would we recover property and get it back into our trust? So that's where we start to look at all sorts of other concepts. That's where we start to look at concepts of tracing. We look at the liability of third parties who might have interfered with our trust, whether it's dishonest assistance or knowing or unconscionable recipients of property, as well as the liability of trustees personally for breach of trust. We think about the problems of exclusion of liability clauses in that context as well, but principally it's about how do we recover, using tracing and other doctrines, property, whether it's the original trust property or substitute property, and reconstitute our trust fund. And then section D deals with the investment of trust funds, and this again very important in practice, very important as a commercial activity in that sense. How do we use trusts as investment mechanisms? So we look at principles of trust instruments and how they might govern investment. We look in detail at the Trustee Act 2000 and concepts like the trustees must invest suitably, they must ensure diversity of their investments, they must ensure they've taken proper advice, and we compare and contrast that with the old case law on prudence. And we look at what that word prudence means. It sounds very old-fashioned, it sounds like it means caution, but actually if you look at some dictionary definitions, it means wisdom and it means taking a profit, as well as being cautious. So we look at what the change is in the 2000 Act. There's a move towards an idea of reasonableness and away from an idea of prudence. But investment now is conducted in parallel with financial regulation. And so we'll also be looking at Financial Conduct Authority regulation and how that might impact on the ways in which professional investment advisors, whether acting as trustees or not, are supposed to deal with their clients and what that might mean in the future for trust investment. We'll look at money laundering regulation and what that should mean for the future of trust investment as well. Very practical, frontline pioneering stuff. Very, very difficult for you to study this kind of material anywhere else, and it's of absolutely central importance to trust law practice, whether that's within the UK or internationally. So this entire course will take you through those issues in great detail and give you an education I'd suggest you can't get anywhere else. Practical and scholarly. What more could you?